of Appeals, Division 1 is now in session.
Please be seated. Welcome. Good morning. We are here today for oral argument in case number MH21 1CA MH210083. Counsel, each side has 20 minutes for your argument. The appellant may reserve time. I would just ask that you do that yourself. There's a clock, or there should be, on that side of the podium. Proceedings are being audio and video recorded, so please introduce yourself and your client when you start. We've conferenced the case, read the briefs, so if you could also keep that in mind as you make your argument, that would be great. And with that, let's get started.
All right. Good morning. May it please the court. My name is Michelle DeWalshy. I'm with the Maricopa County Office of the Legal Advocate, and I represent the appellant CS in this matter. And I'd like to try to reserve 3 minutes for rebuttal, and thank you. CS is committed in the Arizona State Hospital as a sexually violent person based on a non-unanimous jury verdict. In Ramos v. Louisiana, the U.S. Supreme Court recently held that a unanimous verdict is implicit in the right to a jury trial for defendants facing a substantial loss of liberty.
Yeah, I'm sure that's correct. I mean, I think Ramos only deals with criminal cases. I mean, it goes without saying that we're dealing with a loss of liberty, but Ramos, as I understand it, applies only in criminal cases, and this certainly is not a criminal case.
That is correct, Your Honor. It does say in criminal non-petty cases. However, this court in State Ex Rel Romley v. Superior Court, in deciding that Arizona's SVP Act does not include the right to a unanimous jury verdict, relied in part on Johnson v. Louisiana and Apodaca v. Oregon, which were both overturned by the U.S. Supreme Court in Ramos. And so CS is asking this court to revisit its decision in Romley in light of the rationale and the holding in Ramos v. Louisiana, and just to let us know if Romley is still good law.
Well, you agree, I would take it that that we're dealing with civil commitment, and that it's a civil proceeding and not a criminal proceeding. We allow for non-unanimous verdicts in civil cases. So the import of your argument would be that we would have to have unanimous verdicts in civil cases as well as criminal cases.
Well, what I'm urging this court to do is to revisit Romley, because in making its decision in Romley, this court really, relied on Johnson v. Louisiana and Apodaca v. Oregon, and saying, look, a unanimous verdict isn't even necessary in some criminal cases, and so why should we extend it to these civil commitment procedures? What we are asking is that this court revisit that decision in light of the very strong language in Ramos that this right to a jury trial carries with it a right to a unanimous verdict, and whether or not in Arizona, by virtue of allowing jury trials in civil commitment cases in these SVP cases, whether or not that carries with it also this right to a unanimous verdict. CS was convicted with just 7 of 8 jurors, finding that he was a sexually violent person. The court also aired...
Before you move on, Ms.
Oh, no,
Dorsey,
go ahead.
just piggybacking off of Judge Howe, and I think I know the answer to this, but I just want to make sure, because you're urging this court to take a look at Ramos and rely on Ramos, but Ramos specifically is addressing Sixth Amendment, correct?
That is correct.
Which begins in all criminal prosecutions, right?
That is correct. However, in civil commitment proceedings, if you look at Kansas v. Hendricks, these decisions as to whether to allow a unanimous verdict or, require one in civil commitment proceedings and SVP proceedings is largely left up to the states. And so the argument really is that I think wrongly the decision has to be revisited in light of Ramos v. Louisiana, because it is the states, it is a legislature's prerogative to require a unanimous verdict or not. And of the, 21 other states that have SVP proceedings, there are 15 that require or allow for jury trials. Only 2 of those, including Arizona, do not require a unanimous verdict.
Well, that sounds like a very good policy argument, but we don't do policy in court. It sounds like a very good argument for the legislature. Isn't that where you should go instead of here?
Yes, Your Honor, but I would point out that, with State XREL, Romney v. Louisiana, given this court's reliance on 2 cases that have been overturned by the U.S. Supreme Court, that it really would be appropriate for this court to revisit that opinion to provide guidance, for practitioners throughout the state as to whether or not Romney is still good law. I would further point out that if this court does not agree that it should revisit Romney, any, attorney practicing, at just the normal level in the profession in SVP cases would realize that Ramos was decided and that, this court relied on it in Romney. And so the ineffective assistance of counsel claim, I think would apply. Obviously, she did not raise this as an issue below, and, based on the court's precedent in MH21 002-637, the court can, find ineffective assistance of counsel even to unobjected to errors.
One of the grounds for the IAC claim is failing to move for a unanimous jury.
Yes.
If that's the law now, however misguided you or anyone else may think it is, how can that be a basis of an IAC claim?
Your Honor, because in Arizona, the SVP statute is silent as to whether or not a unanimous jury verdict is required. And so the attorney would not be questioning the constitutionality or the law as written. The attorney would be looking at prior case law, which is how we know in Arizona that there is not a right to a unanimous jury verdict, and would note that those 2 cases relied upon by this court have been overturned, and that decision needs to be revisited in Arizona.
Is that how we know? By prior case law, or is it by what's in the statutes?
Well, because it's not explicitly in the statute that there is or there is not a unanimous verdict, yes, I would say that it's Arizona case law. It's Romney that really determines that there is not a requirement, and that the civil, these civil rules.
Didn't you say the other, I think there were 21 states, 19 of them have statutes. So why can't we just look at our statutes and see, well, the legislature hasn't chosen that path?
Well, Your Honor, I would point out that, only 15 of them actually have statutes that allow for or require a jury trial. And so where the jury trial is granted in SVP cases, is that right is granted to defendants. The question is, does the U.S. Supreme Court's decision in Ramos require that that be a unanimous verdict as well. The Court of Appeal, the trial court abused its discretion when it denied 2 motions for judgment as a matter of law as well. First, the trial court erred when it found that Dr. Thornton, the state's expert, was qualified as a competent, competent professional under Arizona's SVP statutes because he was familiar with the treatment programs in Wisconsin, not Arizona. This was an abuse of discretion. It is manifestly unreasonable. It's in violation of ARS 36-37012.
Okay, so what's the basis of your argument? Is the basis of your argument that that question was not asked for the witness to answer whether he met the requirement or not? Or is your argument that he does not meet the requirement?
The argument is that, it's the state's expert, and the state has to show that, he does meet the qualifications pursuant to the statute. The judge in this case actually acknowledged that there was no evidence presented that Dr. Thornton was familiar with Arizona's treatment programs. And so we know that the statute was not adhered to. In civil commitment cases, our courts have said that these statutes must be strictly adhered to in order to protect the due process rights given the substantial liberty interest at stake.
If you are correct in is the remedy to vacate the verdict, or is it for us to have a conditional remand so that the parties can go back to the trial court and have the question asked of the witness, and either he is familiar, in which case it comes back up here and it would be affirmed, or he isn't, in which then the verdict would be vacated and things would be done over again.
Well, I would argue that so much time has passed. I mean, Dr. Thornton certainly could have become familiar with Arizona statutes if he was not before. The problem with that would be that all of his testimony and his reports relied upon, the assumption that he was familiar with Arizona statutes at the time, and that was not shown on the record.
Well, but couldn't the attorney ask that? It's like, well, you may be familiar with it now, but were you familiar with it then?
Well, Your Honor, I mean, I would say that, the court could remand for an evidentiary hearing on that if this court, does find that would remedy this, but honestly, I'm sorry, my argument is that the statute was not adhered to, that this is a civil commitment case, and that these statutes must be adhered to protect due process. And so at the very least, we are asking that CS be given the opportunity for a new trial so that the statutes can be complied with this time around. I would also note that the case relied upon by the judge, the In re Thomas C., that memorandum decision is a really misplaced reliance upon that. First of all, in that case, the challenge to the expert was that while she was familiar with treatment programs in Maricopa County, she was not familiar with treatment programs in other counties, more rural counties in the state. And also in that case, the CV of the doctor was admitted. And so in that case, there was clearly evidence on the record that she was familiar with Arizona's SVP, treatment programs. The question was whether or not, she has to be familiar with it in another county, the county in which the case was originated. And so in reliance on that case is really misplaced, because in this case we know the judge said, I didn't hear any evidence of that. And so because Dr. Thornton doesn't practice in Arizona, and because Dr. Thornton's CV wasn't admitted, and even if it was, would not show that he had practiced in Arizona, then the Thomas C. case really is not even persuasive when it comes to deciding this issue. I would also point out that the court abused its discretion in, denying the motion for judgment as a matter of law after Dr. Thornton testified that CS's serious difficulty controlling his behavior was attributable to his paraphilia in combination with a psychotic disorder. ARS 36-37015 requires, it does not define psychotic disorder as any of the qualifying mental disorders that apply to these SVP cases. And so in allowing the jury to consider the case based on the testimony that was provided, that was erroneous. It was manifestly unreasonable, made on untenable grounds for untenable reasons. It is clear from In re Leon G that the inability to control the behavior or the difficulty in controlling behavior has to be attributed to the mental disorder, and psychotic disorder, even a combination of that with paraphilia, does not qualify under the statute. Because the statutes must be strictly complied with, we're asking that this case be, that his commitment order be vacated and that, it be remanded for further proceedings.
How does a psychiatric expert discern whether the motive for the criminal act is a paraphilia or some other psychosis? It seems like it's kind of 6 in one, half dozen of the other when at best it's intermingled.
Well, I would argue that the statute is clear. It doesn't say, the paraphilia combined with any other mental disorder. It is specifically paraphilia, a personality disorder or a conduct disorder, or a combination of paraphilia, conduct disorder, and the other disorder. So it's very specific. It doesn't allow for a psychotic disorder to be combined with the paraphilia, which Dr. Thornton testified that may give rise to the urges, but it is the psychotic disorder and the rest of who he is that creates this substantial difficulty controlling behavior, and that is not in compliance with the statute. And therefore, the case must be remanded.
So the error was in picking the SVP statute. Could your client have been committed under the general commitment statute for his psychotic disorder?
Well, it would only be if you were a danger to himself or a danger to others. It's a different, obviously by clear and convincing evidence. I would note if that were the case and he was committed, then he would be, basically only committed for up to 12 months. It's usually 6 months inpatient, whereas, and then he'd be entitled to another hearing, whereas here he's only entitled to have it evaluated. He can request a hearing, but he, likely, and this court, said, or the Supreme Court said in Martin v. Weinstein, it is likely for some offenders that it will be a life sentence. And so I would just state that, even if he could have been committed under that, that's not how the state chose to go about it, and that would be a question for another day. And so just quickly to touch on the ineffective assistance of counsel, again, if this court does not find that, that it has to revisit its decision in Romley, I would urge this court to find that this is ineffective assistance of counsel and to reverse and remand for a new trial.
And Mr. Walsh, I know you want to reserve the rest of the time for rebuttal. I do have a question on this for you, so I can ask it now or on rebuttal.
Now is fine.
So for example, in the criminal world, this court doesn't address the merits of an IAC claim on direct appeal.
Correct. Yes, and
What do we do here? Do we address the merits of an IAC claim?
Yes, and the case for that is in MH 2010-002637, where errors were not objected to below, and the court held that they would still review for, harmless error, and that they would address an ineffective assistance of counsel claim in civil commitment proceedings because, there isn't that right to PCR after an appeal as you would get in criminal cases. And with that, I'd like to reserve the rest of my time for rebuttal. Thank you.
Thank you very much. State Counsel.
Thank you. May it please the Court, Deputy County Attorney Robert Walsh, appearing on behalf of the state. I'm going to go in the order that counsel proceeded in. It's also the same order as the briefs. The first issue deals with whether or not the Sixth Amendment requires a unanimous verdict in an SVP case and whether the attorney who represented respondent was ineffective for not objecting when a 7-1 verdict was returned in this case. Judge Howe, your questions were directly on point. The Sixth Amendment only applies to criminal proceedings, and SVP proceedings are civil in nature. And therefore, when we think about what a defendant is entitled to in a criminal context, what does the Supreme Court precedent say? That we have to have a jury find every element of the crime beyond a reasonable doubt, and now in light of Ramos, it's unanimous. We do not have those components in a civil case. Addington versus Texas says in civil commitment cases that clear and convincing evidence is sufficient. There goes one component of the reasonable doubt standard that we have in criminal cases. We also know that courts around the country have confronted claims by people who are confronting civil commitment, involuntary civil commitment. They argue we're entitled to a jury under the Sixth Amendment, and every court that has ever addressed that issue has said, no, these are civil proceedings. You do not have a right to a criminal proceeding. Now, it seems to me that the gateway for the argument that Ramos requires us to revisit Romley is the fact that Romley dealt with an issue of statutory construction. There was a conflict here. 3704 provides that in these types of proceedings that the rules of civil procedure apply. The rules of civil procedure, Rule 49, allows for a non-unanimous verdict. But we also had the provision within the SVP statutes, 363707, that had reasonable doubt as the standard. The real party in interest in Romley, Mr. Clements, argued that the mere fact that the legislature assigned the state the burden of proving the SVP statute's elements beyond a reasonable doubt necessarily meant that the verdict had to be unanimous. While deconstructing that argument, this court said, well, we presume that the legislature knew the law. It would be familiar with the Arizona constitutional provisions and statutes and rules of civil procedure when it chose not to follow the path of other states and require a unanimous verdict, but rather to have our Constitution, Arizona Constitution, Article 2, Section 23, which does not require a unanimous verdict in civil cases, that would be the path. To show that there was no necessary connection between the reasonable doubt burden and the unanimity requirement, that's where the Romley court said, look, there is no historical or traditional link. Take a look at these two Supreme Court cases, Apodaca versus Oregon and Johnson versus Louisiana. But they weren't saying that this was a criminal case. At the very beginning of the opinion, the court acknowledged that this was a civil proceeding. But it was only showing, even in the criminal context, there's no linkage. Now, of course, Ramos has overturned those decisions, but we're forgetting the second component of what this court said. It said this hybrid of a situation where you have a reasonable doubt standard and a lack of a unanimity requirement exists in another context, the right or the context of terminating parental rights. That's completely unaddressed by appellant. In other words, this was a case of statutory construction. Nothing has changed with respect to Ramos. I think in the reply brief, actually, appellant makes the point that she actually shows that there is no Sixth Amendment right to a jury in SVP cases by noting that there are 21 states in the Union that have SVP statutes, yet 6 of them do not require a jury. If the Constitution applied, those 6 states would have to basically rethink their process and say, we have to give them a right under Ramos or under existing Supreme Court precedent under the Sixth Amendment. That was not done.
Counsel?
Yes.
does the IAC claim on the basis really matter here? Because either there is a right or there is not, so it doesn't really matter whether counsel raised the issue or not.
That's correct. I cited cases in that portion of my brief dealing with ineffectiveness that omitting meritless arguments is neither deficient nor prejudicial. So, should the court rule that Romley was correctly decided and unaffected by Ramos, there's no merit to this particular argument, therefore the attorney had no duty to raise it. And to the extent appellant now argues that counsel was ineffective for not making the novel claim, well, I also cited precedent for the proposition that failure to raise novel, available constitutional claims is not deficient performance. So that hopefully answers your question, Judge Howe, does it?
Yeah, well, I'm troubled, as is Judge Williams, about how we handle IAC claims in this context. Generally, at least my limited understanding in mental health cases, is that if there is an IAC claim that has any possible merit, we remain for an evidentiary hearing. So how does that? I'm not so concerned about that here with the unanimous verdict issue, but with the issue with the expert, that troubles me more. Can you address that on the merits and in relation to the IAC claim?
Well, if the court should find that a claim is legally meritless, it can resolve it on direct appeal because there's really no factual finding that needs to be made. But however, we have to remember that Rule 60 provides an opportunity for defendants to raise a claim that they had an ineffective attorney following their trial. I know that the footnote in the MH case from 2010 that you're talking to says that there's quite a bit of discretion, but appellant chose to raise this claim on direct appeal. And there are cases, in Massaro versus United States and others, where the Supreme Court deals with ineffectiveness claims on direct appeal. And basically, if you raise a claim on direct appeal, you basically have to deal with all the impediments of doing that. And I think I'll transition over to the competent professional claim, because one of the things that we have to do is acknowledge the principle that we do not presume ignorance of a witness from a silent record. Now, if Dr. Thornton had testified, he'd been asked directly, are you familiar with the treatment programs here in Arizona? And he said no. Then State versus Miller, which I cited in the fourth section of my brief, would apply. It says that deficiency has to be shown by a demonstrable reality, and that would be such a thing. But we do not presume that someone is ignorant. We do not presume deficient performance, and we do not presume prejudice from a silent record.
But do we presume competence?
Competence by the witness. Well, yes. And let me just take a step back here, and I think this is a really important point. In my brief, I showed the court that when you look at the statutes and when you look at the case law, there's not one single case that says that in order to commit somebody as an SVP, the state must prove that the witness it's calling, that expert, is a competent professional. There is no such requirement. And basically all the state had to do was prove that this person had the qualifying convictions, had a mental disorder. That mental disorder created serious difficulty in controlling their behavior, and as a result of that, there was a high likelihood, that he would reoffend in the future.
But if the witness, you'll understand what I mean, if the witness is bad for whatever lack of qualification, then there would be a lack of evidence on the point that the expert is called to testify on. So the argument that you're making doesn't resolve that issue.
Well, actually it does, because we do not look at whether or not treatment programs, whether or not this defendant, when we look at whether someone's an SVP, the question of whether or not there are available treatment programs in Arizona really doesn't play into the elements that we have in the SVP statute, what the state needs to prove. That's something for the judge to consider after the jury says, yep, this guy's an SVP. the judge has two choices. They could commit the person to the state hospital or do a less restrictive means. It will be at that point that a competent professional's knowledge of the treatment programs in Arizona would have some applicability. But here, I mean, there is absolutely no doubt that this doctor has been practicing in this field for 40 years, ran the prisons in England, did the same thing in Wisconsin, was an SVP panel member in Iowa. He's testified 27 cases throughout the country within the last year.
Before this, did this expert ever testify in Arizona in an earlier case?
Nor did the defense expert, Dr. Roselle. Neither of them did. This was their first foray.
This expert, so this was the first time?
It was, for both experts. And I think it's important to note, psychology is the same regardless of where you are, whether it be in the United States.
But we have a requirement that the expert be familiar with SVP programs in Arizona. So I think you're answering this, but my question is really, but for the waiver argument that the trial counsel didn't timely raise this, didn't under Rule 16, didn't object in the joint pretrial statement, and waited till the state rested their case before raising it. But for that waiver argument, an absolute lack of anything in the record addressing this specific question for this expert, the state's position is it's still fine?
That's because it's not something that the jury needs to find. It's not an element of an SVP proceeding. And quite honestly, what's really troubling about this...
But the court needs to find it, correct?
It could have been something subject to Rule 104, but nobody challenged it. And I think that's what's really troubling here. Is let's just take a step back. Let's not deny that the reason why the CV of this doctor was not presented into evidence was because defense counsel objected when the state moved it into evidence. There was a strategic reason for this, and I think what was going on was defense counsel was sandbagging the state. It was holding back on this. It filed 3 motions in limine, the defense did, to challenge aspects of Dr. Thornton's testimony because it had interviewed him. They did not indicate this was an issue at the joint pretrial statement. And by the way, please take a look at the conservatorship of Hart case, because there the defense made an untimely objection during trial to an expert. They had made objections to all sorts of other experts and everything else, but they lay in wait. And this court said that that's too late. And I think it's very important when I cite to you 3704, it said the rules of civil procedure apply. That means Rule 16F2D. But the problem is that because defense counsel didn't even raise it there, raise it during voir dire, had she done voir dire, then that evidence would have come through. Had she cross-examined him, the state would have had an ability to do something about it on redirect. They waited until the close of evidence. Now, you could take a look at this and say, well, gosh, that might be a deficient attorney. No, it isn't. This is somebody who is waiting in the weeds, waiting for the state to rest its case and then do exactly what happened with the Missouri Supreme Court case that I cited to you, Henry George S.
Well, counsel, you may be correct in your characterization of what happened, but we certainly can't make that factual determination. Aren't you arguing, isn't the basis of your argument the reason why we generally need to send IAC claims back?
I think the rule would be this. Let's just take a step back, and I'm going to hearken back to Rule 32 cases. Prior to State versus Sprites, in Arizona, if a defendant raised a claim on the merits, an ineffectiveness claim on direct appeal, the only thing that could ever happen in those cases is for the court to say, sorry, this has no merit, we're denying relief. After Sprites, the court said, no, you now have to raise this in a Rule 32 so that you could have evidentiary development. But prior to Sprites being decided, if the case lacked merit, if the ineffectiveness claim lacked merit, the court was empowered to deny it. And here I've given very, very substantial case law that says that, the only thing that didn't happen here was I didn't say, Dr. Thornton, are you familiar with treatment programs here in Arizona? That's the only thing that didn't happen. Now, we're presuming, if you're appellant, that the mere fact he was never asked that question means he was necessarily ignorant. Of course, that may not be the case. And I think that Dr. Roselle's testimony helps cure that. I think that's what the judge was trying to say. when you look at the fact that he was a director of the SVP program in Wisconsin, and you look at his entire list of credentials, Dr. Roselle had never testified in Arizona, but these two men had practiced in the same states. And what Dr. Roselle said was the treatment, when asked, are you familiar with the treatment programs in Arizona? Look at his answer. His answer was, well, yeah, they all have the same components. They all have, basically relapse prevention. They have disclosure cycle. They have anger management. They have all the same components. So that would be the same thing that Dr. Thornton would testify to. And quite honestly, Dr. Thornton wound up writing a lot of the studies that Dr. Roselle relied upon. I have 5 minutes left. I'd like to address... Okay.
Can we do a conditional remand?
There is authority when you have a timely objection, but the court does not rule. State versus Rodriguez, 145 Arizona Reporter, a 1985 Court of Appeals case, where that remanded when there was a timely objection and it wasn't there. Of course, you're going to have to deal with the burden of proof in terms of saying, when did the doctor learn what when is going to be the real problem here. But the thing that's very upsetting to me, at least, is that had this objection been raised according to the rules, and if Dr. Thornton did not know, then what would have happened is he would have studied up. It probably would have taken him not even a day if he didn't know, and it would have been cured. But the very fact that this wasn't raised is because the defendant knew that this was a very bad case for him. His pedophilic history is terrible. And this was basically wading in the weeds and playing technicalities. And that is your reasonable tactics. I think the counsel was hoping that the judge would grant the JMOL.
Is it really laying in the weeds when it's right there in the statute?
In terms of that, well, there's nothing in the statute that requires the state to prove that this person that's testifying is a competent professional. It's not something for the jury to decide. So it's not even a jury issue. So there is nothing, we also have to remember that the court appointed Dr. Thornton. And so, you have the subsection of the definition of a competent professional that says court approved and meeting court guidelines, which means Rule 702, 703, or 704. And nobody's challenged this doctor's ability to render opinions on the topics he mentioned. Treatment has nothing to do with whether or not he's an SVP. The state moved in limine to keep that out.
Right, the statute says that the expert should be familiar with the treatment program in Arizona, right?
Yes.
So how is that laying in the weeds, for your adversary or opponent?
Well, this court held an INRI MH 2009-001264 where a similar objection, in fact, it was during an appeal that the respondent argued, wait a second, the expert wasn't a qualified physician. This court followed a state versus Ryan, a state of Ryan, and said that was waived. The point is, if it can be waived, that basically ends the question. I have 2 minutes left, and I want to quickly address something with respect to the schizoaffective disorder. This judge, at the time of the case, had only really one witness to deal with, and heard that this defendant, prior to his diagnosis and development of schizoaffective disorder, had molested children after being on probation, after having been on jail, having served a 7-year prison term, after getting charged with and released, and then he reoffends. He makes statements to the effect that he is attracted to children, and he has a very difficult time resisting those urges. And then when he feels like he's been mistreated, he just stops caring and he does what he wants. And he masturbated to images or mental images of children while he was in prison and didn't even tell Dr. Roselle, which I think would be like consciousness of guilt, not telling the truth during that time period. When we were taking a look at the testimony in front of the judge, he said, yes, defense counsel tried to press upon this witness. You're saying the schizoaffective disorder combined with the pedophilia is what's causing it. And the doctor kept saying, no, no, no. There's some language in the reply brief about how when the prosecutor asked squarely in the redirect, is the schizoaffective disorder alone sufficient? He answered the pedophilic disorder in the context of the rest of who he is, yes. In the reply brief, appellant says, well, that means a schizoaffective disorder. No, it doesn't. Take a look. I'm going to ask the court at one point in time to look at page 9 and 10 of my answering brief, because there you'll see the question before that. And the question was, what effect does the schizoaffective disorder have on the pedophilic diagnosis? And so he talks about how there's no evidence that he's been diagnosed with at the time he was offending in the community. It's something that seemed to develop while he was in prison. But while he was in the community, he still had problems with impulsiveness and anger and irritability and feeling badly treated by other people. And those problems, this is what I want you to hear, those problems seem to be part of who he is and interact with his pedophilia. It gives context to what he meant on page 10 when asked, the pedophilic disorder, however alone, is that sufficient to say that he's highly probable to reoffend in the future and sexually? The answer, the pedophilic disorder in the context of the rest of who he is. A reasonable jury could so construe this statement to mean that the pedophilic disorder alone was sufficient. I'm out of time. Thank you very much.
Thank you, counsel. Rebuttal.
I would just like to briefly address a lot of the points that were made regarding the competent professional. Counsel, my colleague, had stated that, this seems like a trial strategy, to sandbag. I would point to State v. Escalante, where the court held attorneys' strategy is irrelevant. If this court is reviewing for fundamental error or harmless error, the question is, was the statute strictly adhered to? We know that it was not. And I would also point out that what the state is asking this court to do is to find that 36-3701, is frivolous. It doesn't even have to be proven. And if it does have to be proven, it has to be proven by the defense or challenged ahead of time. And I would say 16F refers to Section 3, which is the Rule 702, Rules of Evidence Challenge, under Daubert, in a request for a Daubert hearing. Otherwise, in these civil commitment cases, these statutes demand more than just what is required under 702, and one of those is that the doctor demonstrate familiarity with the Arizona treatments that are available. And then finally, I would also say that, I would just ask this court to reconsider its decision in Romley and to look at, find an abuse of discretion and to reverse this, vacate the order of commitment and remand for further proceedings. Thank you.
Thank you. Thank you both for your excellent arguments this morning. We will take the matter under advisement, have a decision in due course, and with that, we are adjourned.